All rise. The Court of Appeals Division 1 is now in session.
Thank you. Please be seated. This is the time set for argument in our civil number 17-240, DYER versus City of Yuma. Each side will have 20 minutes in which to argue its position. The appellant may reserve a portion of that time for rebuttal argument, counsel, but you'll need to keep track of that time for yourself. We've read the briefs and conference this case. We're familiar with the facts and issues presented. Would each of you, as you begin your argument, identify yourself and the party you represent? Counsel for appellant may proceed.
May it please the court, my name is Michael Pang. I'm from the law firm of Yen, Pilch, and Landine, and I represent the appellant, Davida Dyer. I'll try and reserve a portion of my time for rebuttal as well. The City of Yuma terminated Davida Dyer 4.5 years ago. The four-member Yuma Merit System Board, along with the hearing officer, held a full evidentiary hearing in which Dyer and the city were allowed to examine and cross-examine a dozen witnesses and provide over 500 pages of documentary evidence. After that appeal hearing, the Merit Board moved to reject the termination and to reinstate Dyer, specifically finding that the city and the Yuma Police Department failed to prove that Ms. Dyer was untruthful, falsified records, or exercised unbecoming conduct. Now, the only issue before this court is whether the Merit Board's decision was arbitrary or without reasonable justification under ARS 38-1101K. Under that statute, the city administrator may reject the Merit Board's decision only if the Merit Board's decision was arbitrary or without reasonable justification. The question is not whether the city administrator stated or found that the Merit Board's decision was arbitrary or without reasonable justification. Rather, the question is, under the plain language of the statute, 38-1101K, whether the Merit Board's decision as a matter of law was arbitrary or without reasonable justification. Because the Merit Board's decision was not arbitrary or without reasonable justification, the city administrator under that statute may not reject the Merit Board's decision, and the city must reinstate Dyer. Any other result by the city administrator...
Appeal that's already happened?
It has already
You're
happened.
Describing the issue in the last appeal, aren't you?
Correct. In Dyer 1, this court found that the city administrator in his original decision from 2014 did not meet the requirements of 38-1101K. It remanded to the Superior Court with instructions for further action in compliance with that statute. In Dyer 1, this court found that the city administrator did not meet the first requirement, 38-1101K, that in order to reject the Merit Board's decision, that decision must be arbitrary or without reasonable justification. But he did satisfy the second requirement, stating reasons for the rejection. So this court already found that the original decision did not comply with the statute. It was remanded to the Superior Court. And before the Superior Court could instruct the city or the city administrator to do anything, the city administrator issued a revised decision, again rejecting the Merit Board's decision and upholding termination. So it's the city administrator's decision is back on appeal, but it still does not comply with the statute. As a matter of law, the Merit Board's decision was not arbitrary or without reasonable justification, and that's a standard that's defined by our courts.
So are you contending that the mandate in Dyer 1 compels a certain result here, or are you treating this as an entirely fresh issue?
I think it does compel a different result. The statute, there's nothing in the plain language of the statute that allows the city administrator to revise his decision if he doesn't comply with the statute in the first place. I think that in order to comply with the statute, if the city administrator's decision did not meet the first requirement of the statute, in other words, if the Merit Board's decision was not arbitrary or without reasonable justification.
You keep talking about the substance of the decision, and I thought what we said in the first appeal was that there was no finding that the Merit Board's decision was arbitrary. I don't believe we held that the Merit Board's decision was not arbitrary, or that I don't think we held that the Merit Board's decision was justified. We just said you can't terminate her without a finding to the contrary?
Well, the statute requires that in order to terminate or to reject the merit board's decision, that decision must be arbitrary as a matter of law. The city administrator, I think, tries to make findings in his revised decision that the merit board's decision was arbitrary, but as a matter of law, he actually doesn't make a finding. It's an incorrect finding that the merit board's decision was arbitrary. So,
Well, what you say in your brief is that the city should be ordered to comply with DYER 1 and reinstate DYER. I don't see in DYER 1 anything in the mandate that says she has to be reinstated.
correct. DYER 1.
But why do you say that in your brief then?
Because DYER 1 ordered the Superior Court in the city to comply with the statute. DYER 1 specifically found that in the first paragraph of the memorandum decision that the city did not comply with because the city did not comply with the requirements of the statute, it was not entitled to terminate DYER's employment.
But there's procedural noncompliance and substantive noncompliance. The fact that there was procedural noncompliance once doesn't mean that the substantive result is foreordained on remand.
Correct, but I think here there's also substantive noncompliance. I don't think the city can show or make a finding that the merit board's decision was arbitrary, and that the city administrator therefore has discretion to reject the merit board's decision. The city administrator's revised decision, all of the evidence that's outlined in that decision is directly from the audio transcript, the record of the merit board hearing. One of the requirements, or the definition of arbitrary, is an unreasoning action without consideration in disregard of facts and circumstances. All the evidence that the city administrator puts in his revised decision is evidence that was presented directly to the merit board at the merit board hearing. I don't think he can show that the merit board did not consider or disregarded any of that evidence. In addition, the definition of without reasonable justification is the lack of evidence sufficiently strong to justify a reasonable person in the belief that the acts charged are true. Again, there's no evidence in the record, in the briefs or in the city administrator's decision, that the merit board's decision lacks sufficiently strong evidence. Importantly, under that standard, for the merit board's decision to be without reasonable justification, the merit board's decision must lack sufficiently strong evidence. Whether the city administrator's decision is supported by sufficiently strong evidence is not the standard for without reasonable justification as defined by MCSO. The city administrator's revised decision is highly selective. Again, he says that he reviewed the audio transcript of the hearing. It's a 368-page transcript. His decision only includes a very small portion of that evidence.
You'd be amazed how many pages of transcript we have to review to produce a 6-page memo decision.
And
I don't think we can infer that the review didn't happen because the decision was short.
And again, the standard is not that the city administrator reviewed the record. The finding that needs to be made is that the merit board, their decision lacked evidence, or that they did not consider or disregarded evidence. It's very different for the city administrator to say that his decision is supported by the evidence, or that he considered the evidence.
Well, the city administrator said that he found that the merit board failed to consider certain facts, right?
Correct.
Isn't that grounds on which to say that the merit board's decision was arbitrary?
Well, he says that the merit board failed to consider certain facts, but then the facts that he lists, again, were facts, evidence, witnesses that were produced directly to the merit board at its evidentiary hearing. I don't know how he can say that the merit board didn't consider those facts or that evidence when it was presented directly to the merit board.
Well, let's abstract this then to an appellate proceeding for a moment. Assume that this court has to find that a determination by a superior court was arbitrary, and we cite certain facts that were presented to the superior court that are so compelling and overwhelming that we can't understand how a reasonable fact finder could come up with the result below. Isn't that analogous, and couldn't we find such a decision arbitrary?
I think so. I think the city administrator's decision, if he's referring to facts or evidence or circumstances in terms of how persuasive they are or how compelling they are, I think MCSO also provides some guidance as to whether or not the merit board's decision versus the city administrator's decision is arbitrary. In the MCSO case, that court held that where there's room for two opinions, the action, in this case the merit board's action, is not arbitrary if exercised honestly and upon due consideration, even though it may be believed that an erroneous conclusion has been reached. And in this case, in DYER 1, the court found that the record evidence is subject to dispute. The merit board and the city administrator are looking at the same record evidence, but they're coming to different conclusions, different opinions. The merit board reviewed that evidence and decided that DYER needed to be reinstated, whereas the city administrator reviewed that same evidence and decided that termination should be upheld. But there's nothing in the record, there's no evidence in the briefs, in the record, or even in the city administrator's decision itself that the merit board did not act honestly or upon due consideration of any of that evidence in reaching its conclusion and coming to its opinion that DYER should be reinstated. And again, just because there's different opinions, different conclusions that both of those decisions meet, doesn't mean that the merit board's decision was arbitrary. And again, under 381101K, the question is whether the merit board's decision was arbitrary.
Well, the conduct at issue here is highly problematic, to put it gently, right?
Yeah, so I mean, that's the whole reason why I went into appeal, why she was terminated in the first place.
Sure. And is it not possible for the city administrator to conclude that when you have an officer who might well subject an innocent person to prosecution, that there is not room for two opinions about the merit of that conduct? I frankly have difficulty seeing how there is room for two opinions about such conduct.
Well, I think the city administrator could come to that decision, but I think the merit board, considering all of the evidence that was presented at the merit hearing, testimony of a dozen witnesses, 500 pages of exhibits, et cetera, I think they could also have come to the conclusion, which they did, that DYER was not untruthful, that there was not conduct unbecoming. The city administrator, his decision, it ignores DYER's testimony. She had a reason why she may have changed her story or changed her report or recanted her original report. She stated that she was under pressure from supervisors. She provided reasons why she did what she did. And I think the merit board, considering that evidence and her testimony, could come to the conclusion that the city was wrong, that they did not meet their burden of proof in proving that there was any misconduct.
So your read of the merit board's decision is that it resolved a credibility issue rather than a remedy issue.
It could be, and I think that was the merit board's decision. That was for them to make. I know the city administrator in his revised decision points to a lot of credibility issues with regards to witnesses. And I don't think that's a decision that the city administrator can make. First of all, credibility isn't a factor in the arbitrary without reasonable justification standard. But even if it was, I don't think that's a decision that the city administrator could make. He was not present at the merit board's hearing, which was closed to the public. I think only the merit board can really make a determination of credibility.
And are you saying that the credibility is really the crux of the issue, or is the crux of the issue, again, the remedy? Assuming that an officer took two different positions on the identity of the suspect, whether that is sufficient grounds for termination?
I think the question is whether the merit board had sufficient grounds to agree with DYER and to come to a different conclusion than the city did here.
Okay.
So ultimately the question is whether or not the merit board's decision, their decision to reinstate DYER, to reverse the termination, was arbitrary without reasonable justification.
So, I mean, in essence, is your position that the city was required to defer to the merit board's conclusion, and we are also required to defer to the merit board's conclusion?
Correct. Under the statute, if the merit board's decision was not arbitrary or without reasonable justification, the city must defer to their decision and adopt their decision.
On what grounds can the city find that there was no reasonable justification? There has to be some circumstance that allows it to make that decision. Otherwise, it's purely superfluous.
Well, I think if the arbitrariness standard is that the merit board didn't consider disregarded evidence, their decision might be arbitrary if they suppressed evidence or did not allow parties to call witnesses, which none of that happened. Nobody has argued that that's happened.
But without reasonable justification implies some review of the substance of the decision, doesn't it?
The without reasonable justification concerns the sufficiency of evidence to support the merit board's decision. And the city administrator never says that the merit board's decision lacked sufficient evidence, sufficiently strong evidence. Rather, the city administrator says that his decision is supported by sufficiently strong evidence, which is not the standard for without reasonable justification as defined in MCSO. So I think that in order to comply with the statute, if the merit board's decision as a matter of law was not arbitrary or without reasonable justification, the city must reinstate DYER. If that requirement is not met, then the city administrator does not have discretion to reject the merit board's decision.
Well, let's say you're right. Why is the remedy reinstatement? Why isn't the remedy yet another remand?
That's already what happened.
Well, I know, but if on I mean, we've seen cases, plenty of cases, where there are multiple remands.
Right.
And if the city got it wrong again, as you're suggesting, I don't see how that translates to reinstatement.
Well, this court has already actually determined that where the merit board's decision as a matter of law is clearly not arbitrary without reasonable justification, that the court can remand with specific instructions to reinstate the employee. And that was the
big difference between your argument that the city got it wrong by applying the wrong standard of review and an argument that we should find that the situation is so compelling that she should be reinstated. This court normally doesn't make those kinds of factual determinations.
I think in this case it's a legal determination. The standard in 381101K is whether or not the merit board's decision was arbitrary without reasonable justification. That's a well-defined legal standard that I think this court can answer. And it can answer in the negative based on the fact that there was a full evidentiary hearing, and also the fact that the city administrator, on remand, his revised decision does not show that the decision was arbitrary.
You're saying it doesn't show that, or it doesn't assert that?
It asserts it, but I think it asserts incorrectly that it was arbitrary.
I'm just having trouble with the idea that we're supposed to intervene and make the substantive determination that's left to somebody, either the merit board or the city.
Right. I think ultimately, because it's a question of law, this court can make that determination.
I mean, we're no sort of all-knowing, superintending employment board for the state.
It seems as though you're asking us to make a rather powerful factual determination that I, for one, don't feel equipped to make on this record.
And again, I don't think it would be a factual determination. I think it would be applying the definition of arbitrary without reason or without reasonable justification, a legal standard, to the proceedings for the merit board, to the merit board's decision.
But our review is whether the city administrator applied the correct legal standard, not whether the board made a decision that was adequately grounded.
I think maybe there's two steps. It's determining whether the city administrator applied the standard under 381101K, but that standard under the statute requires an examination of the merit board's decision.
But if we find that the city that the administrator did not apply the correct standard of review, aren't we done at that point? I mean, that would represent a victory for you, but it wouldn't represent perhaps the kind of victory you want.
I think that if you find that the city administrator did not or cannot apply the correct standard under the statute, the only result that's possible under the statute is that DYER be reinstated.
Why do we get to cannot? Isn't the only question whether he did not?
I think that even if he did not, the same result would be required, that the merit board's decision must be upheld and that DYER must be reinstated. I'll reserve the rest of my time for rebuttal.
Thank you, counsel.
Good morning, and may it please the court. I'm John Barnes with Michelle Molinario for the city of Yuma. As the court has already pointed out, there's already been an appeal in this case, and the court in that case had a clear model for what to say if it wanted to require the officer's reinstatement on remand. In the memorandum decision, the court cited to a case called Burnt v. Department of Corrections, I think. And in that case, based on undisputed facts, the court was able to hold as a matter of law that the employer lacked discretion to reinstate the officer, or to reject the reinstatement recommendation because the facts were undisputed and did not support termination. In this case, the court didn't use any language or make any findings similar to what we see in the Burnt case, and actually went the other way in observing that the record evidence was subject to dispute, and it was the city's job in the first instance to make any findings based on disputed evidence. And so Ms. Dyer wrongly argues that she's entitled to reinstatement on remand under the memorandum decision in this case. And there are a couple of points in the briefs I would like to address, unless there are any questions.
Well, let's say we agree with you about the import of the remand, or the mandate from DYER 1. Aren't we then presented with the question whether a similar error occurred on remand?
I'm sorry, I'm not sure I followed it.
Well, if we agree that the mandate in DYER 1 did not require reinstatement, but required further proceedings with the result yet to be determined, right? Then don't we have to look at whether the city administrator applied the correct standard of review? DYER 1?
Well, based on the court's observation in the first memorandum decision that the evidence was subject to dispute and that it was the city's job in the first instance to make the findings, it follows then that the city administrator was in a position to make the findings that are required under the statute and resolve any conflicts in the evidence based on the weight of the evidence.
But your colleague is arguing that the city administrator didn't make the required findings under the required standard of review. Don't we have to look at that question?
Well, I think there's two issues there. There's no dispute that he made the required findings. He said that the merit board's recommendation was arbitrary and that it lacked reasonable justification. And what Ms. Dyer is arguing is that he had no basis for making that finding. But
Well, I think the argument is that the finding is inadequate because it amounts to nothing more than that the city disagrees with the merit board's conclusion. That's not sufficient to demonstrate the arbitrariness of the merit board's conclusion.
If you look at the merit board hearing transcript, the merit board spelled out what its role was, and that was it's a recommending body with no decision-making authority. And so, in other words, its standard of review was deferential to the city. It was not entitled to substitute its judgment for that of the city when there's evidence in the record supporting the city's decision. And here, the transcript clearly shows that there's a ton of evidence supporting termination.
The board has to defer to the administrator? Is that what you're contending?
The board has to review the termination deferentially.
Okay. But then the board's recommendation is reviewed by the administrator, correct?
Right.
And at that point, doesn't the administrator have some measure of deference to the board?
Well, so it all goes back to the action. My colleague said something like the language in MCSO where the action meant the merit board recommendation, and really what we're talking about is the termination. The merit board that's what's on review, is the decision to terminate. So the merit board's duty is to evaluate whether there's evidence to support the termination, and if there is, it has no discretion to overrule the city's decision to terminate. And that's what the city administrator looks at, whether the merit board properly evaluated whether there was evidence supporting.
So you're saying the city then on that subsequent review is looking to see whether the merit board sufficiently deferred to the initial decision?
Essentially, Judge.
A lot of deference.
I have to tell you that we went through a series of these cases, I don't know, late 90s or early 2000s, because we're always looking for, in these cases involving agency determinations, we're always looking for somebody to defer to. But at some point, the difference stops and somebody has the final say, and it's usually not us, at least as to the substance of these things.
Right, and I think, Judge, if you look at the memorandum decision from our first appeal, the court says...
I was on the panel.
That's right, you were. I remember that. Judge Norris, in writing for the court, said that the legislature put the onus on the city to make the findings under the statute. So the legislature in the statute makes the city the finder of fact. And those are the facts that are under review, that being the arbitrariness finding. And so I think the court, if there's evidence supporting that finding by the city that the merit board acted arbitrarily, this court has to defer to that finding. And I think the case law bears that out. If you look at even at cases predating the statute, Hamilton, and then post-statute cases, the Stant case, and then and even before that, the MCSO case, they all describe the appellate court standard of review as deferential to the employer.
Sometimes it just helps to talk about specifics. As I understand it, what was central to the city's determination that DYER would be terminated is the fact that her operational effectiveness was basically ruined by the county attorney putting her on the Brady list, which I assume is some sort of list where they have to divulge to criminal defendants that a witness in the case has been known to be untruthful. Have I got that right?
I'm not sure you're looking at the right decision by the city administrator, Judge, because that sounds more like the one we had in the first case.
Okay.
And so in the decision we had by the city administrator in this case, the administrator set forth pages of findings under both the arbitrary standard and the lacking reasonable justification standard, and that was but one of them. And it was really sort of an afterthought. The crux of the administrator's decision in this case was the mountain of witness testimony showing that the officer lied in a report, which we all know opens the city up to civil rights claims.
Well, so going back to the first determination by the city, which again, appeared to me, at least at the time, and still appears to me to be based on this problem with DYER's being an effectual operating member of the department, based on this Brady problem, that if in addition the city had said, based on this fact and others, we determined that the merit board's conclusion was arbitrary and not justified, would we have upheld it then the first time if those other findings had been made?
I don't think we can really speculate on that, Judge, because the court never reached that issue. It stopped short of statutory compliance, and finding that statute was not satisfied in the first appeal required a remand back to the city to make the findings, because the evidence was disputed. And as the court noted, this court is not usually a fact finder, and so it had to go back to the city, or the city administrator, to make those findings as it saw fit under the statute. And I just wanted to comment briefly on the posture of this case, if I may. Ms. DYER argues wrongly that the trial court committed reversible error by not entering a remand order, sending the case back to the city, and any error in that regard was invited because that's not what she asked for. She asked the trial court to enter an order reinstating her, forcing the city to respond and explain why that relief was not appropriate. But there was no error in the first place, because a formal remand order by the trial court would have been a futile act. The city would have made all the same findings that we're here discussing today, and we all would have ended up back here arguing over whether those findings are sufficient to comply with the statute as elucidated in the first appeal.
So is that really the issue before us then, is whether those findings are sufficient to comply with the statute?
I think so, Judge. That's what the court required in the first case, and that's what we're here talking about today. So barring any other questions, I think that's all from me.
Thank you, counsel.
So I just wanted to address the issue of deference to the employer's original disciplinary decision. I think Hamilton is completely distinguishable. That case happened well before 3811-01K was ever enacted. That case also didn't involve an arbitrariness standard that applied to, in that case, the Mesa Personnel Appeals Board's decision, or that constrained the city manager's discretion to adopt or reject that decision. Also, with regards to the issue in MCSO, concerning deference to the original termination decision. MCSO, and again, the arbitrary without reasonable justification standard is the same as an MCSO, but an MCSO, that standard came out of a Maricopa County Employee Merit System rule that required the County Merit Commission to uphold discipline unless the discipline was arbitrary or without reasonable cause. The YUMA Merit System Board, the Merit Board in our case, doesn't have such a rule. In our case, the Merit Board essentially had discretion to reject DYER's termination whether or not that discipline was arbitrary without reasonable justification, and instead, the city administrator is constrained by that standard pursuant to 381101K, and he can only reject the Merit Board's decision if that decision, not the underlying discipline, was arbitrary or without reasonable justification. So
I don't remember if it's the MCSO case that you're citing, but we had a series of cases back then where we really gave some juice to the Maricopa County Merit System Commission and said essentially that conclusions of that body had to be deferred to by the sheriff. And I'm pretty sure the Supreme Court rebuked us for that and said, no, the Merit Commission's job is to recommend, and it's the sheriff's job to decide. Have I got that wrong?
No, I think I'm not sure which case you're referring to, but here the city administrator.
The Supreme Court at some point had to overrule one of our decisions, and I think they declined to follow one of their own precedents that they felt were misleading us.
I think fair merit systems generally defer to the evidentiary, the fact finder. In this case, it was the Merit Board. But I think here as well, the city administrator's final administrative decision is directly constrained by the statute 381101K. So whether or not prior cases deferred to one body or the other, I think here the city administrator's discretion is clearly constrained by the statute. Now, I see that I'm out of time, so unless you have any other questions, I think that's it.
Thank you, counsel. Thank you both for your arguments. We'll take the matter under advisement. We'll issue our decision in due course. We'll be at recess.